Welcome everyone to the fifth and final webinar in our series on business data ethics. My name is Dennis Hirsch, and I am the faculty director of the Program on Data and Governance, a program of the Moritz College of Law and the Translational Data Analytics Institute at The Ohio State University. It's been a wonderful experience to host these webinars this month, and I'm very excited about our final webinar today on the regulation of algorithms. Before I introduce our panel, I'd like to ask Gates Garrity-Rokas, Vice President and Chief Compliance Officer at The Ohio State University, to open our proceedings and say a few words to the audience.
Thanks, Dennis. And on behalf of the Ohio State University and the Moritz College of Law, welcome back to this terrific webinar. Dennis has pulled together a terrific panel for us on the regulation of algorithms. To each of our panelists, thanks so much for joining us. I'm sorry we can't do this in person. To the participants, we really appreciate your engagement and your questions. Speaking as a practitioner, committed to advancing ethics and meeting regulations, I'm very eager to learn from all of you. So thank you for joining us. Thanks, Dennis.
Thanks, Gates. Section 108 of the Consumer Online Privacy Rights Act, one of the many privacy bills that is currently before the Congress, prohibits data processing that discriminates on the basis of race, gender, religion, and other protected classifications when allocating opportunities for housing, employment, credit, and education. Now, this is an excellent requirement, but it raises a question. What is an anti-discrimination provision doing in a privacy bill? The rest of the section gives us a clue. It requires companies that use algorithmic decision-making to allocate housing, employment, credit, and education opportunities. It requires them to complete an algorithmic impact assessment that, among other things, explains how the company tested its algorithmic decision-making process to ensure accuracy, fairness, and lack of bias or discrimination. What we see in Section 108 of this bill and in a number of the other privacy bills currently before Congress is an expansion of regulation to address the harms, bias, unfairness, manipulation, opacity that corporate use of advanced analytics can create. What we see, I think, is a new legal paradigm emerging to govern advanced analytics and AI. What will this new paradigm look like? What should it look like? What has been proposed or enacted thus far? Can law and policy successfully protect us against the harms that advanced analytics and AI can create? Today's panelists are deeply engaged in the emerging law and policy of algorithms, advanced analytics, and AI. And they're going to share with us today their insights into what's happening in this area and where we are headed. Before we get to their thoughts, I just wanted to connect what we're talking about today with what we've been discussing for the past 4 webinars. So in the prior webinars, we focused on how companies seek to manage their use of advanced analytics and AI so that they don't cause bias, unfairness, and manipulation and other harms. Today's presenters are going to be talking about very similar technologies and very similar risks, but a different regulator, the government, rather than corporate self-regulation. Of course, government regulators often want to know what companies are doing in an area that they intend to regulate. And companies engaged in self-regulation often want to know where government regulators are headed. One of the reasons that our research team decided to study business data ethics was to provide policymakers with more information about what companies are doing in the field of business data ethics. So today we get to hear where law and policy is headed and perhaps begin to relate it back to the business data ethics practices that we've seen emerging in the private sector. Before starting today's panel, I would like to take a moment to thank our platinum sponsor, Facebook, and our gold sponsor, Cover My Meds. Your support helped to make these webinars possible. Thank you. I also want to give a special thanks to Christina Drummond, former program manager for the Program on Data and Governance, who helped to formulate the initial vision for this forum, and Jillian Thompson, our current program assistant, who helped us figure out how to do this virtually and gave many great suggestions and ideas that helped make these events a success. Let's turn now to our panel and begin the discussion. Recent bills in Congress have proposed a variety of statutes for regulating algorithms and advanced analytics. And our first panelist, Cam Carey, has analyzed these bills from his position at the Brookings, from his position as a distinguished visiting fellow at the Brookings Institution. Cam, what are the basic regulatory models or strategies that you see emerging? And if you were to design a regulatory model for the governance of advanced analytics and AI, what characteristics would it have? And which of the existing bills comes closest to this model?
Well, thank you, Dennis. I approach this really from the standpoint of looking at, what's the right kind of regulatory model here? How do we best translate data governance, which is broadly what this program is about, into law and to regulation. And data governance is really about bringing norms and values into practice. It is certainly about ethics, but I think it beyond just ethics, privacy, human impact, social impact, sustainability, all important values. And I think when we're dealing with technology, the challenge in doing that is that it is highly dynamic. It is moving fast. It's changing fast, and highly variable. In the privacy context, Helen Nissenbaum has taught us that context is so important. We see in a host of technological areas that there's sort of an arms race. Cybersecurity, the attackers figure out something new, and as soon as the defenses are stronger. Ad tech, every time somebody comes up with a way of blocking ads, preventing tracking, people find a way around that. And the lesson that I draw from that is, we need regulation that is iterative and adaptive. This is exactly the way the technology functions. And I think law and policy need to be able to do that. So to establish boundaries, we need boundaries, clearly. We need boundaries on the collection and the use of data. We need boundaries and how that's used. And I think, to answer your opening question, why is discrimination a privacy issue? Because it is based on the use of personal information and using information in ways that is harmful to people that have an underlying interest in that information. It's about how you treat people. So I think for examples of taking an iterative and adaptive approach here, I hold out, for example, the NIST cybersecurity framework, something that I had some hand in sort of developing conceptually when I was at the U.S. Department of Commerce. It is not intended as a one-size-fits-all approach, not intended to be a checklist. It is intended to make companies focus on their risk, their profile, and make decisions around that. And the approach that we took at the Brookings Institution in the very detailed report that we did on the legislation you referred to, Senator Cantwell's COPRA bill, and the other leading Senate bill from Senator Roger Wicker, who's the chair of the Senate Commerce Committee, to try to reconcile those, was to try to shift the emphasis onto the ways that companies behave and their obligations, and to center it on boundaries on the collection, use, and transfer of data, on duties of loyalty and care. So that duty to respect people, to act in their interests, and on risk, and like the NIST cybersecurity framework, to focus on the risks. I think, and part of that is dealing with algorithms. I think the bills from Wicker and from Cantwell, Senator Maria Cantwell, the ranking member of the committee, which is the COPRA bill, are both in the ballpark. They're sort of in the ballpark of each other. They haven't done enough to shift the obligations onto to businesses. And I think when it comes to algorithms, the subject here today, I think there is more that they can do. Less about specifically regulating the outcomes, because I think we still have a lot to learn about how algorithms are operating, but to create more transparency, to focus, to create obligations for companies to look at the outcomes of what they're doing. That I think is the key way forward. I mean, one of my Brookings colleagues, Nicole Turner-Lee, did a report on algorithms, and one of the key lessons was you've got to be continuously measuring and looking at outcomes and at inputs. So I think ultimately here the debate here is often framed as sort of innovation versus privacy or fairness or ethics. And I think it's more about certainty versus flexibility. But trust is essential here. That's based on, I think, predictability. But we also need adaptability. We also need creativity. So I think putting the focus on risk, to me, forces people to look at outcomes, and not to focus on the General Data Protection Regulation, sort of doing all the steps of documenting your processing, but really looking at what are the objectives in terms of protecting individuals. So I think that to me is the key objective of the regulatory approach, and I think getting the balance between flexibility and certainty promotes that.
Ken, thank you for some very interesting thoughts. And in particular, some of the directions I heard you talking about, the shift from, putting all the burden on the individual to having the company share more of that and increase duties, and moving, in addition to more procedural requirements, to thinking about risk and thinking about outcomes, are really interesting directions here. So our second panelist, Michelle Richardson, has been part of the policy discussion in this area for some time now through her role as director of the Data and Privacy Project at the Center for Democracy and Technology. Michelle, what are the main themes, the big stories that are driving the increased focus on the regulation of advanced analytics and AI as you see it? And do you think that the regulatory system will have to adapt to the new technologies, or is it the field of advanced analytics that will have to adapt to regulatory realities, or some of both? Interested in your thoughts.
Yeah, thank you. So I think that the types of events and programs that we are looking at and are really grabbing so much attention from regulators really fall into a few major categories. And that is where the regulation is focusing. And the attention is happening now for a few reasons. One, the tools are now just embedded in everything, right? And people are much more aware that decisions are being made about them in important ways with these tools. The media is covering these issues much better than they used to. They're now able to break down technology and explain it in a way that is really accessible to people. And I think social media too, right, is making it easy to spread information about how these tools are working. Before, these sorts of stories would only be found in a very limited set of publications, right? They would be considered a long form piece or scientific writing, but now it is in the public conscience. And we really see a focus on bias and the types of instances where people are denied opportunities in very classical areas that we've always worried about, you know, education, employment, housing, and credit, right? And I think those are few reasons. One is just the moral imperative. You know, we have decided in this country for a very long time, and as well as, you know, Europe and through GDPR, that some of these categories are just so crucial to, you know, a normal functioning life that we have to be extra stringent. You know, it's not entertainment or low-level consumerism. You need to proactively get out there and stop the discrimination. But also because there is legal liability here in a number of areas, right? Our civil rights laws are tech neutral. They cover everything from whether you can lift a heavy bag to a pencil and paper test to what we're seeing now, which is really much more automated processes for determining whose resume will be seen, right? A computer interview process that is recorded and then processed, and other things that may bake bias into decisions that are otherwise being protected. And, you know, I think there's a question about fit for purpose too, right? When we look at these sorts of categories, we'll often see the people who build the system say, well, what we're doing is we're just trying to get more of the same, right? We look at who we already hired or who we've already admitted to the school, and we just want more of them. And that is actually quite a damning admission, right? Of that there is not necessarily a blank canvas, maybe proactive efforts to diversify who gets into the system, but really a commitment to just doing more of the same. I think what we see as a response is that, one, decision makers are focusing in on these areas, right? So Congress has had hearings on things like banking and big data, right? When at the state level, concerns about how AI is implemented through criminal justice systems, right? It can be used for things like determining whether someone gets bail or how long someone's sentence is. And we see the government trying to make decisions about how it will use it itself through its own procurement process, what standards it will set. And I think this is maybe one of the hidden ways forward here. I would point to a paper that CDT just put out a couple of weeks ago on government benefits determinations, how they use AI and how that affects people with disabilities especially. You have special rights already against your government when they make decisions about you, and we don't need much more regulation to facilitate that. So that is definitely a way forward. There is a lot going on here, right? State, federal, executive and legislative branches. So we would recommend focusing on a few things in the very near future. So one, for example, is the ballot initiative in California next week, right? In less than a week, we'll know if the California Privacy Act has been updated. And if so, it will have language in there directing the state attorney general to issue new guidelines about the use of AI, how people can opt out, and what transparency is required. So that may be one of the closer sort of regulatory jumps to affect this area. I'd also watch the NDAA, right? It's the annual funding bill for our defense agencies here in the US. One of the versions has language that would actually, commit federal agencies to issue new guidelines about how they will purchase technology. And those often, spread throughout the industry, even if it is a more commercial facing product. They become sort of the de facto standards in the US over time. And we do look for what happens after the election. A change in the White House could actually change, for example, enforcement priorities under existing laws with the current agencies and the types of cases they choose to bring. I know Jim and Travis will talk a little bit about later, but there are already some of these authorities in place. So I think that's sort of the short-term view. Of course, over a longer period, you're going to see things like the legislation Cam mentioned. You're going to see states maybe get into the fray, right? And it's hard to figure out the timeline on this, but it's, the next 5 years, right? I think we'll see some significant changes.
Thank you, Michelle. That's really interesting. And particularly, kind of thinking about existing laws and how they can be purposed or repurposed to address some of these issues coming up in the AI context that we've seen, in our analog or more traditional computing context. And then also, what new laws are needed. So really interesting to think about that. We're pleased to have with us today two government officials. And the first is Jim Trilling from the Division of Privacy and Identity Protection at the FTC, Federal Trade Commission. And Jim, I'm interested in your thoughts as to the role that the FTC can play or is playing in the governance of advanced analytics and AI, and whether you think that the commission can play this role successfully with its current authorities and tools, or whether it needs additional authorities and tools in order to be an effective regulator in this area and protect people.
Great, thanks, Dennis, and thanks for having us here today. I want to start off at the outset by saying my remarks today are my own and don't necessarily reflect the views of the Federal Trade Commission or any of our individual commissioners. For those who don't know, the FTC is an independent agency led by 5 Senate-confirmed commissioners who serve staggered 7-year terms, and we enforce both consumer protection and competition laws. We take a 3-pronged approach to issues dealing with the collection and use of data, including with respect to algorithmic decision-making and artificial intelligence, civil law enforcement, policy work, which could include things like hosting public fora where stakeholders share their views, the issuance of best practice recommendations, and then also we issue consumer and business guidance. Across each of those areas, we emphasize that algorithmic decision-making and AI tools should be transparent, explainable, fair, and empirically sound, and that companies should be accountable for their use of those tools. That said, we do enforce several technology-neutral laws that can be applied to algorithmic decision-making and AI. Our most generally applicable authority is Section 5 of the Federal Trade Commission Act, which prohibits deceptive or unfair acts or practices. Deception entails misrepresenting or omitting a material fact that is likely to mislead a consumer acting reasonably under the circumstances. So an example could include something like making a claim about the accuracy or fairness of algorithmic decisions without having substantiation for the claim. An unfair act or practice is one that causes or is likely to cause substantial injury to consumers that consumers cannot reasonably avoid, and that is not outweighed to benefit or to competition. So for example, if a healthcare company used an algorithm that impacted consumers' access to healthcare based on biased results and failed to take reasonable steps to correct that bias, the FTC could challenge those practices as unfair. We also enforce the Fair Credit Reporting Act, which applies to consumer reporting. Consumer reporting agencies include credit bureaus, employment background screening companies, and other companies that provide services for making consumer eligibility decisions. So businesses such as check authorization services or tenant screening services. Among other things, consumer reporting agencies must implement reasonable procedures to ensure maximum possible accuracy of consumer reports and provide consumers with access to their own information, along with the ability to correct errors. So those provisions may enable consumers to seek information about an outcome that was driven by an algorithmic decision. We also enforce the Equal Credit Opportunity Act, which prohibits credit discrimination on the basis of race, color, religion, national origin, sex, marital status, age, or because you receive public assistance. There are both disparate treatment and disparate impact violations of the Equal Credit Opportunity Act. A disparate impact occurs when a company employs a facially neutral policy or practice that has a disproportionate adverse impact on a protected class, unless those practices or policies further a legitimate business need that cannot reasonably be achieved by means that are less disparate in their impact. For example, if a lender is using proxies to determine groups of consumers to target for high interest credit, and those proxies overlap with protected classes, the FTC could investigate and, if appropriate, pursue violations under the Equal Credit Opportunity Act. On the policy side, one example of the policy initiative related to algorithmic decision-making is the FTC's January 2016 report entitled Big Data, a Tool for Exclusion or Inclusion. And I would point people to our website for that report. I would also encourage people to visit our website to review a January 2020 blog post from our Director of Bureau of Consumer Protection entitled Using Artificial Intelligence and Algorithms. And I'm going to briefly touch on Dennis's question about potential gaps in our authority. I think we'll probably get back to that. But the short answer is yes, there are potential gaps, and some of those gaps are tied up in debates about what are the harms that we're potentially trying to protect against when it comes to collection and use of consumer data, be it to train algorithms and to lead to algorithmic decision-making, or more broadly in other contexts. So for example, under our unfairness authority, there's the risk that the FTC might view a certain practice as being injurious, but a court might disagree that the injury that the FTC would point to is the type of substantial injury that is covered by the unfairness prong of the FTC Act. Another example of a potential gap would be companies that are operating behind the scenes to develop algorithmic decision-making technology that might not make claims about that technology, or might not have a direct relationship with consumers, where it might be a challenge to bring a deception claim. And then one other broad thing I would point out about our enforcement authority is we don't have the authority under Section 5 of the FTC Act to impose financial penalties for first-time violations of the Act. And that can raise questions about whether or not our authority is sufficient to deter unlawful conduct. And for that reason, the FTC on a bipartisan basis has long supported comprehensive privacy legislation that would include civil penalty authority under Section 5 of the FTC Act.
Thank you, Jim. That's a really interesting and comprehensive overview of the various authorities that the FTC could bring to bear in this area, and really clear articulation of how those authorities might work here. So thanks for that. We turn now to Travis Hall. Travis is a policy analyst at the National Telecommunications and Information Administration, the NTIA, which is an executive branch agency that is the principal advisor to the president on issues of telecommunications and information policy. And so, Travis, your position at the NTIA gives you quite a broad view of policy in this area, both at the national level and frankly at the international level as well. So when you look across the federal government, what steps do you see agencies taking to start to address the emerging risks from advanced analytics and AI? And what do you see happening on the international level, through various types of regulatory frameworks or agreements that are being struck, like the one that the OECD put forth? Do you see those as useful? And if so, which of these international frameworks do you think is most useful as a model?
Great, thanks so much. So let me start, as others did, with just a tiny little bit of background about who we are at NTIA and why we operate in this space, because some people know us pretty well, but many don't, because we're pretty small. Although we do tend to punch above our weight class a bit. So at NTIA, we have a number of different functions, most of them, specifically related to telecommunications, like spectrum management. However, my office is, along with our Office of International Affairs, in charge of developing telecommunication and information policy for the administration. And that covers a really broad range of issues, because it's, telecommunications and information stuff part has exploded. And so we are responsible for helping the administration develop its policy priorities and positions on issues such as privacy and cybersecurity and emerging technology. And we've worked on a number of different issues, including the development of the Internet of Things, drone policy, and now artificial intelligence. And the thing is that there is a large swath of activities happening across the federal government on artificial intelligence. It has been a priority area for this administration, and so there have been quite a number of activities, and a lot of that falls into the development and promotion of the technology side of things, funding, creation of research institutes, things like that. But there also has been work on this particular type of conversation about, the regulation and the ethical boundaries of that. And so with that, one of the things that the administration specifically has done recently is it had the Office of Management and Budget, OMB, did put out a set of draft guidelines. I believe that they are in their next round of revisions. They got put out for public comment. We got public comments, and they are being revised for finalization on how regulators should treat and approach artificial intelligence. The Department of Defense has also put forward 5 principles through which it views based upon which they will approach the ethical use of artificial intelligence. And there is also the National Security Commission on Artificial Intelligence that was set up by Congress to look at kind of that broad scale, but it does actually have a specific work stream focused on the ethical use of artificial intelligence. And you mentioned the international side of things. NTIA specifically was heavily involved in the development of the OECD principles on artificial intelligence. And we are also actively engaged in those types of conversations across the board at a number of different various forums. But one in particular that is a recent development would be the US-EU Global Forum on Artificial Intelligence. And let me just make sure that I'm getting the the name right on that one. It might not be forum. But anyhow, internationally, there's tons of stuff going on as well. EU has put out a white paper for comment on artificial intelligence and the way in which it should be treated ethically, how it should be developed ethically, and how it should be regulated. We have been active participants. The U.S. government has been active participants in engaging with them on that. Many countries, India comes to mind immediately, but many countries have put out national strategies for artificial intelligence. And so there is just a ton of activity in this space. And in terms of kind of some of the convergence and where the things are most helpful, there's, like Cam said, a lot of the focus is on the question of bias, of how do you actually figure out transparency, right? I mean, it's interesting because I've been talking about artificial intelligence. This particular webinar is about algorithms. Algorithms have been in use for a really long time, and how they are being used now, and in what ways that's different, and in what ways artificial intelligence changes or doesn't change that kind of relationship is a thorny and interesting conversation. And transparency is oftentimes a key component of that, because oftentimes the people who are making the algorithms themselves, when machine learning is involved, you can't really kind of like crack it open and say, okay, this is exactly how it works, because what you are hoping for with the development of these algorithms is the maximizing the efficiency of the decision-making process, and kind of like coming up with, in many cases, what you're looking for is you're coming up with irrational correlations and connections, things that, somebody who's just looking at something and says, oh, well, obviously people who like to sleep in like to stay up late, right? Like that kind of like obvious correlation thing, what oftentimes you end up coming out with is things that, might make sense if you truly think about it hard, but that the data kind of like brings forth. But of course, the data bringing forth those kind of irrational types of activities can bring about harm, right? Where you put in a bunch of data, not thinking that you are creating something that is going to create bias or harmful outcomes, but then it does then lead to that. And so, Cam made the distinction between, outcomes and, that we're not at the point yet where we can like really focus on the outcomes, and we're focusing on the transparency. And I think that that's right. And that's where a lot of these principles and other areas are really kind of pushing, with the understanding though, that, all of us on the call are very well aware that in the privacy space itself, it's kind of become just a truism that notice and choice doesn't really work very well in the privacy space. And so one of the things that I see as a need to kind of like be careful about in, pushing on transparency, just transparency, is that it doesn't become then just simply another kind of form of notice where the burden is placed on the consumer to figure out, well, okay, we're being told how the algorithm works, or we're being told that the decisions are being made by an algorithm, but there's actually very little leverage or ability for us to, as consumers or individuals, to actually do anything with that. So, and then in terms of like where I would say, some of the real like fire is I do think that the U.S. government is throwing its weight behind the OECD principles and the OECD as a forum for the basis for international conversations. And domestically, again, I think that a lot of eyes are going to be on that OMB guidelines that will be coming out soon.
Great. Thank you, Travis. That's really interesting. I just want to say to the audience, we have a Q&A function, and if you have questions that you'd like to ask to our panelists, please submit them through the Q&A and I will ask them. I'm going to ask a few questions first. I'll direct them at particular panelists, but any of the panelists are welcome to join in. And just before I do that, I saw, Cam had a comment that he wanted to make, I think on what Travis was saying. So Cam?
Yeah, thanks, Dennis. And to partly sort of echo and partly respond to what Travis said, his description of some of the processes in the government really put me in mind of about 4 years ago at this time, as the Obama administration was winding down and doing a report on artificial intelligence, finish up and leave on the table for the next administration. I participated in a workshop that NTIA and other agencies held. And it's extraordinary to me how much this discussion has moved since that time in terms of understanding of AI, in terms of smoking out issues like algorithmic fairness and the ways that discrimination operates, and a tremendous amount of policy focus. Travis mentioned a forum on cooperation in AI. I don't know if they're referring to something I'm leading at Brookings, which is started as a transatlantic forum, is now international, including a number of countries. But we learned in the course of that Canada was the first country to adopt a national AI strategy in 2017. At this juncture, there are now 60 countries that have adopted strategies on sort of all kinds of levels, and about 400 different frameworks, governments, companies, academia, and so on AI ethics, AI principles. So there's an extraordinary amount of focus on this. But I think it does go to what I said at the outset. We are still learning a lot about these issues. So I sort of come back to my regulatory approach that we do need to have some action forcing rules, but understand those are not the last word.
Just picking up on what Cam was saying and asking our other panelists, do you agree with that characterization that there's kind of an explosion of activity and thinking going on in various parts of government, national, international, in this area?
So I definitely agree that there is an explosion of thinking and activity and a more robust discussion of what issues should be considered. For example, if there is new legislation or if agencies are charged with implementing rules, I think that there is still a fair amount of healthy debate as to what merits protection and what harms we're trying to protect against. I think, again, hearkening back to broader issues about data governance and privacy, not necessarily limited to algorithmic decision making. I think what people can observe in hearings, be it in Congress or in state legislatures, and in bills, or even in proposals from agencies that might be engaged in rulemaking, even though there may be more coalescence around what issues should be on the table and what should be considered. I think there is still a fair amount of healthy debate as to what the parameters should be and what the goal should be once those issues are identified.
Dennis, I think that's right. And I think what's still outstanding is the hard question of, well, what happens when these programs fail or we find them to actually cause harm, right? And that in some ways is not a technology question. There's a lot of politics and policy hesitancy to be really explicit about what to do with technology, right? It's not just about AI. We see this across the board when the government is trying to weigh in on these tools. So there's a lot, but hopefully over time, this will sort of coalesce into a single approach. I think what we're hoping is that what we could do is try to focus on things like making people liable for the outcome, right, of their use and how they work backwards from there and address those risks and problems is up to them. That gives them incredible flexibility, right, about how to still design their programs or maybe do risk assessments like Cam mentioned to ferret out where the problems are. But that will be the important backstop at the end of the day, right? That's how a lot of our laws work now. It shifts the burden onto the companies, and that's probably the right place for it on something like this. That's where it's just so complicated and so high stakes at the same time.
Well, just a follow-up question from you. This is from one of our audience members. Can you mention this kind of AI-specific dimensions to the current California privacy initiative? Can you describe what those are? And, should we anticipate any guidance from the California AG with respect to governance of AI?
It's hard to predict these things. And if this new ballot initiative passes next week, it's very long. It actually covers a lot of issues, both substantively and directing the AG to do new guidelines and regulations. So I think it's going to take a very long time, let's say, to work out some of the details of how it's going to be applied, how people change their systems, and then enforcement start. But what it does call out is regulations governing access and opt-out rights with respect to the use of automated decision-making, including profiling and requiring businesses' response to access requests to include meaningful information about the logic involved in the decision-making process. So that's going to force some transparency there, not just, I would think, on individuals, like, why did you make this decision about me, but also how does the system work more broadly? I'm sadly forgetting sort of what the deadline is for when these have to come out, but these things usually are kind of like 1 or 2 years down the road, even if it passes next week.
We know that the first California privacy initiative drove the CCPA, and so a lot of activity at the federal level and state level in privacy. Perhaps we'll see something similar with respect to AI if this one passes. Travis, I'm afraid I might have cut you off before in the prior question. Was there something you wanted to add?
Yeah, no, totally. And this is kind of a little bit to one of the questions that was asked in the chat or one of the recent questions in the chat about whether there's going to be a single regulator. And one of the insights that I would just bring to the table that isn't anything new or terribly novel, it's just simply hasn't been mentioned yet, is that all of this is going to permeate other types of regulations, right? That there's other this conversation, there may be some kind of regulation or law or conversation around algorithms writ large, but most of the conversations on this topic are already happening in kind of the more narrow specific fields where you have HUD making decisions about discrimination and algorithms, where I think, one of the areas that doesn't get talked about too much, at least in tech policy circles so much, often is labor and labor law and how algorithms play a role in kind of like the management of individuals. When we certainly are seeing it a lot in terms of schools and education and to Michelle's earlier point about this becoming a more salient public issue, I think we had our first AI specific protest happen in England against the test outcomes. where people, actually were out holding signs saying F the algorithm. And, that might be kind of like a little bit of a new thing, but it might become more of a regular thing and more of a regular thing in a lot of different spaces where kind of broad-based algorithmic regulation probably, I mean, might fall into kind of an FTC Section 5 authority kind of space where, you know, there is that kind of like nebulous stuff that, you know, just does need someone to step in when something goes wrong. But you will see a lot of regulations that are already in place to stop harm having to grapple with the rising importance and use of algorithms. And also that they will be using algorithms probably themselves and how that is actually going to function and work. And I mean, this is not regulation, but, you know, you do see in sentencing guidelines, oftentimes algorithms are brought in to help and make initial decisions or initial risk determinations. And so, yeah.
No, go ahead, Travis, sorry.
Anyhow, just to answer that question, I don't see there being a specific algorithmic regulator, right? Although you could see, you know, kind of an FTC style enforcement or more authority granted to like the FTC itself to do that kind of broad-based work, whereas most of the other regulation would probably continue in those different silos or be created new for specific new things like facial recognition technology.
Very interesting. And
likely what's going to be, what will likely happen is if there is not more sort of declarative federal action here, it's going to explode at the state level. So if you look back over the last 20 years, the states were the first actors on things like drones, license plate readers, you know, it's evolved over the years. Location information, right, was hot for a few years. Facial recognition right now is something that's really a target of advocacy, but AI is now on the list, the very short list of probably the riskiest technology, right? And so it's very possible that we start seeing state or even maybe city regulation, right? Some of these very large cities try to get in on this themselves, passing something, you know, maybe it is just transparency or opt-in or something like that. But I think that is the long-term risk of not having something that's a little more aggressive at the federal level.
And just on the topic of like state and local, I mean, New York City was kind of at the forefront of this with their attempts to do some work on the transparency of algorithms that they themselves are using, right? That, you know, they're contracting out to companies to do this work and trying to get some transparency into how the algorithms that they themselves are contracting out are functioning. And with one of the biggest difficulties in a lot of this transparency piece being trade secrets. Right, how public can companies be actually in the code and the functioning of the algorithm? You know, then this is one of the reasons why explainability is kind of like a hot buzzword, is because you want to be able to explain how it works without necessarily sharing the source code.
So, and I think, you know, there is I see a trend in the discussions, and I think a lot of discussions set out to say we need to do something broadly with AI algorithms. And then move towards much more specific contexts, whether it's facial recognition or others. But as Travis talked about, you know, a lot of these things move into sectoral channels. So, you know, automated vehicles, all right, that's a transportation issue that may be different from regulation in other areas. We see this in the European Union, where you know, new commission came in last year, and first, okay, we're going to regulate artificial intelligence. We're going to legislate ethics for AI, and very quickly, as people started to move into that discussion concretely, it has moved to much more. All right, let's regulate in specific areas, high-risk applications, whether it's transportation or the impact on people. And I think that applies here. I think, you know, you can have due process requirements for significant algorithmic decisions that affect people. You can deal with discriminatory outcomes. And I think there, you know, HUD was mentioned. I think that's moved in the wrong direction. You know, discrimination law has long had disparate impact tests. And that needs to be an important part of discrimination in this context, because if you are talking about an algorithm, if you are talking about technology, you know, only the company that is using that can parse it, explain it, and justify the discrimination. So you cannot put the burden on people who may be the victims of that to show how that's discriminatory. You got to shift the burden, as that's major reason for those kinds of tests, and then it applies much more strongly even when you're talking about algorithms that are so complex that sometimes even the companies themselves don't understand. That's part of the challenge with algorithmic transparency and explainability.
So we're almost out of time here. Any of our panelists, are there final thoughts or additional thoughts you'd like to share before we end?
Well, I would be remiss if I didn't circle back to the question about where this authority should lie if there is new federal legislation. So fully accounting for subject matter expertise on issues like housing that have been highlighted. We at the FTC are unusually, if not uniquely, positioned in terms of having experience with data flow and data usage, both by looking at it through a consumer protection and a competition lens. We do have a Bureau of Economics that can do substantial work in terms of analysis when it comes to things like a possible disparate impact claim. I think there are advantages to having authorities reside in independent agencies that are structured like ours, where there is always bipartisan leadership, and also we're working all the time with the limited resources that we currently have to expand the number of technologists that we have that can work with the attorney staff to really do the type of analysis that's been mentioned, to delve into some of the complexities of how algorithms might work, both the inputs and the outputs.
Great. You hear that, Congress? FTC is ready to go. Folks, I think we've unfortunately got to end it here. This has been really a fascinating discussion, and just a tremendous, terrific way to kind of cap off this month of discussions about data ethics and the governance of advanced analytics and AI. It's really been fun for us at Ohio State and the program on data and governance. Audience members, I hope that it's been enjoyable and interesting for you. We really appreciate your attention and giving of your time to engage in these issues with us. Personally, I'm a little bit sorry that it's over. This has been, really, really interesting and exciting to engage with so many people who are thinking deeply about these issues. I do think that our goal here was to start a conversation, and hopefully we've done that. And we welcome opportunities to continue to engage with others in this conversation. Reach out to us at the Program on Data and Governance or shoot me an email. We'd like to continue this conversation with all of you. And again, thanks to our panelists. Thanks to everybody at Ohio State that's helped to make this a success. And thanks to our audience for being a part of it.